Hi, everybody. This is Mikkel, Judge Martin, CA. Do we have all the parties to start this hearing?
This is Wesley Loy, co-counsel for the plaintiff, I believe so.
Okay. If all the parties could show their cameras or turn on their cameras, that'd be much appreciated for Judge to see everybody during this hearing as well.
Good morning, everyone. Can you all hear me okay?
Good morning, Your Honor. Yes, I can.
Okay, good. Let's get started. This is CV2025-009899. It is the time set for a status conference regarding two discovery disputes, both of which have been filed under Rule 26D. And let me begin with the appearances of counsel, starting with counsel for the plaintiff. Ms. O'Keefe.
Good morning, Your Honor. Sarah O'Keefe, counsel for KSY.
Thank you. And for the defense.
Good morning, Your Honor. Sarah Rock and Ross Meyer on behalf of Becca and Kasem Holdings.
Thank you. Mr. Lloyd, would you like to announce?
Good morning, Your Honor. Wesley Loy on behalf of the counter defendants KSY and Haley Yang.
Thank you. All right, everyone, just so you know, I've got two monitors up. I'm taking notes, so you may see me looking this way and that. That's the only reason why. All right, so I've looked at both of the 26Ds. Any progress on either of those fronts since they were filed? Ms. O'Keefe?
Not with respect to mine regarding written discovery, Your Honor.
All right. Ms. Rock?
No, Your Honor. I do have some updates on the status and how we're trying to proceed and kind of what's going on our end when you're ready to hear that information.
Okay. Well, why don't we start with plaintiff's written discovery? That was one of the 26Ds. And Ms. O'Keefe, you can take us out.
Yes, thank you, Your Honor. Just to give you a little bit of background, since I know that you're relatively new to this case, Booksmart is a small bookkeeping firm, and it was authorized and signed an engagement agreement with Kaizen Holdings in the fall of 2024. And it sued for the unpaid balance of the work under that contract, which was $12,297.50. After an unsuccessful motion to dismiss, Kaizen answered with a 6-count, 120-paragraph counterclaim seeking no less than $50,000, plus punitive damages and attorney's fees and costs. Under the current scheduling order, which was from March 30th, the parties are set to be at a settlement conference by September 18th, and discovery closes on October 30th. My dispute is relatively narrow. In April, I served written discovery. Kaizen responded, and nothing has been amended since. So I will identify the three overarching problems and then offer one request. First, the answers are not under oath. The only signature is counsel's, and there's no verification. The rules require that. And that matters because of the second problem. Second, Kaizen has given us some numbers for damages, but not a computation. So Kaizen's disclosure statements contain a list of dollar figures. Bloom Rock, who's the replacement accountant, those invoices, a $300 some odd late fee, and then two lines that just read penalties and interest due to Booksmart termination of the agreement. Those are for $17,818.98 and $13,463.51. What I asked for in interrogatories 7-8 is different, and it has never been provided. So we had asked for an amount for how these items were calculated. We asked for which item of Booksmart's work supposedly that was attributed to, and we asked for the documents supporting each one and what Kaizen did to mitigate its damages. Those two lines for penalties and interest total, roughly $31,000, and that's nearly, half of everything that Kaizen has identified. There is no explanation that's been provided to us so far regarding which taxing authority, which property, which periods this came from, or how either figure was computed. And we have not been given a document behind either one. The only tax return that's been produced so far is from 2023, which was a year before the events at issue. And interrogatory number 6 specifically asked Kaizen to identify which tasks KSY supposedly performed efficiently. And its answer was that Mr. Sillers, who's with the replacement accountant Bloomrock, will be able to provide more information. So Kaizen has told us, what it paid, but it has never told us what my client caused it to pay. As for mitigation, the last part of interrogatory 8, it wasn't addressed at all, not even by objection. And this is why the computation matters more. Kaizen has produced a June email from its own principal, Joe Vladeck, dated October 11th, 2025, and that's a year after my client had gone, about Rustica, an entity that my client was never engaged to work on. And it's addressed to Kaizen's replacement bookkeeper, and it reads, "The money for the taxes is still in Rustica. Did you still not make that payment? These penalties and interest compounding are out of control. We can't afford these late filings." What this shows is why the attribution matters, and Kaizen has never given us that attribution. I'm asking that Kaizen be required to state how it attributes the $31,000 some odd dollars in penalties and interest to my client. And the section of Kaizen's own disclosure statement that's captioned "Computation and Measure of Damages" reads in its entirety. Kaizen Holdings seeks damages based on the harms suffered as stated herein at the amount to be proven at trial. Kaizen Holdings will supplement this statement with additional calculations as soon as reasonably possible. At a minimum, Kaizen Holdings seeks its reasonable attorney's fees along with additional damages incurred. And that's the identical paragraph across all of its disclosure statements. So we have a list of invoices amount is not a computation, and none of this is under oath. Third, the documents. Each of the 5 requests for productions that were served were answered with generally the same sentence: "Defendant has disclosed all documents in their possession." And the majority of those 5 responses followed with a citation to the entire Bates labeled production at that time. The production, which was actually only 1 through 145, and now the production runs over 682. No document was specifically identified in any request, and no response states whether anything is being withheld, which Rule 34B3C requires. Request 3 asked for the audit, the analysis, and the work papers behind Kaizen's contention that our work had to be redone. What arrived were just audit logs, 7,500 entries of machine-generated list of who signed in and who clicked what. No document is matched to any request, and no response states whether anything is being withheld. Kaizen's counterclaim really rests on the audit that has never been produced. And so additionally, they mentioned that there would be a privilege log. We have not seen one. No log's been served, and there were privilege objections. And with respect to the RFAs, there are 2 that mark deny, but the answer indicates that there's an admission there. And so we would ask for amended answers to all of these written discovery. I'm not asking for sanctions today. I would like to have a proposed order, filed with the court, perhaps some additional briefing, but maybe that's not necessary for my dispute. But I would like to have Kaizen be accountable and have dates certain where they are required to provide the information that we've requested.
All right, thank you, Ms. O'Keefe. Ms. Rock, you're up.
Yes, Your Honor. I think generally just going on, I'd kind of like to explain to the court what's been going on and what is causing some of these delays on our end. First and foremost, we aren't withholding any of the information. My client relies on people who are sophisticated. She's obviously not a bookkeeper. and really relied on, the plaintiff in this case, and then in turn, Bloomrock and Berta Sillers, who completed the work afterwards. I have informed counsel, I believe on multiple occasions, that the information requested was with Bloomrock and that Bertis had the information as to any audit logs, any information that explained what was or wasn't completed by their client. And really what it comes down to is that her client did not complete the work. They then terminated the agreement without a 30-day notice period and only provided a $1,000 discount. Because of that information and when it occurred, it really did leave my client stranded and shows she was required to get a new bookkeeper to go back and do the work. What has happened during the course of this litigation is that Mr. Sillers has indicated that he does not want to be involved. He has essentially done a complete 180 and has indicated that he's not going to testify and going to explain what was wrong with the work, and he's changed the information that was originally indicated to Case and Holdings, and all of his statements and previous information about the delays, about the work that needed to be redone, all the specifics he indicated that he had. But when it came time to get that information from him, he's no longer complying. With that being said, we have, I'm waiting to get confirmation as to whether or not it was served. It's being served today. I believe it should be served later today. We've subpoenaed his records. We've sent out a deposition request, not only for him in his individual capacity, for a 30B6 deposition. We also have requested a deposition for Haley and her company to really get to the bottom as to what's going on in this case. And then we've also filed a separate complaint against Bertis individually and through his entity for his actions that really may result for this causing more damages to this litigation. And so if we find it, necessary, we will likely be filing a motion to consolidate once that's served as well. At the time, Bertis was going to be a fact witness and explain, what happened, the work he had to do, and things of that nature. Since he's changed his position and is no longer really being helpful in this case, it is creating the need for us to get an expert witness. I'm looking at two. I can probably have that finalized shortly. I've disclosed one who we may use, but again, I think it's really just creating a need for someone to actually have to go in and evaluate the work that was done between these two bookkeepers, because both have affected my client. And at this point, we do need to get to the bottom of it, and we're just having to take a route that was not expected. So as far as verification, I'm happy to comply with that and get that done if the court sets an order. But for the other things, it's information that I don't have, that's not in my client's possession, that we've told them where it is, how to get it. They have not done so. We're taking it over and going to try and get it for everybody in this case, because my client has an interest in getting this issue resolved as well.
Okay. So if I'm reading these tea leaves correctly, this started as a roughly $27,000 claim. Now we are deep into the weeds. Neither of you can see a way out. Is that roughly right? And so we're just gonna go down. And this road is going to be very time consuming and very expensive. This is how we're going to do it. I mean, I'm not too pleased about it, but sometimes there's no alternative. But counsel, you're both good, smart lawyers. I mean, I'm at a little bit of a loss how we got to where we are today. Ms. Rock?
I mean, Your Honor, I think, without saying too much, my client feels like she was wronged. And I think that we've tried to settle this early on. We did try and give Ms. O'Keefe information indicating that our client is not one to just back off for the sake of backing off, and I think I'm probably not saying it as eloquently, but I think that for her, who made the mistakes is really important, and she wasn't going to pay that 13,000 or 12,000 for only $1,000 discount when that wasn't explained, and then she's getting